Good morning, everyone. Welcome back to JI Week 2024. Today is day 3, and on behalf of the Judicial Education Institute, I'd like to formally start today's proceedings. I'd like to take this time to welcome our presenter, our esteemed presenter, Justice Maureen Rajnauth Lee, who's joining us from the Caribbean Court of Justice. Justice Rajnauth Lee has had an illustrious career as a judge, and I'm going to share her bio in the chat. It's included in the program. So as to not take any time from today's presentation, I'm going to hand us over immediately to Justice Rajnauth Lee. Good morning, Justice Rajnauth Lee.
Good morning, Antonio, and good morning to everyone on the call. I bring greetings from the Caribbean Court of Justice to the Honorable Chief Justice, Mrs. Mabel Ajaman, Honorable Chief Justice of the Turks and Caicos Islands, and I thank her and the JEI for this opportunity to speak on what has become, I think, one of my favorite topics, how we can improve justice for vulnerable people. I hope you wouldn't mind if I take this time to send special greetings to my dear friend of many, many, many years, the Honorable Mrs. Justice Alice York Suhon, now President of the Court of Appeal of the Turks and Caicos Islands. I say a special hello to my friend. Antonio, I want to start, and all those on the call, I'm hoping that people will come in so that they can hear this story. This is based on something that happened before the court in Trinidad and Tobago. And I was a judge looking at and having to deal with this issue. And this was about what I call an opening story. So I think you could see from the PowerPoint that is up that there is an old house and an elderly woman by her old house. This case involved an elderly woman who lived in a rural neighborhood in central Trinidad. She did not read or write or sign her name. In the words of her own lawyer, the elderly woman did not speak the Queen's English. Those were the lawyers, that was the lawyer's evidence before me. And I can tell you all on the call that that was an understatement. Her dialect was very difficult to understand, even for me as a Trini. She was also hard of hearing, and she was not in the best of health. Her short-term memory was very poor. Her husband had died, leaving her with a son, his wife, and a granddaughter. The family had received little formal education. Only the granddaughter had a few CXC passes and worked as a temporary clerk in a government office. The husband had left this elderly woman with an old property, but it was located in a neighborhood which was rapidly developing and increasing in value. She had sold that property for much less than it was worth. In fact, she did not know the value of the property. And it is what we call in Trinidad and Tobago, we say it was RPO property. Other places refer to it as registered land. So this elderly lady came to court to set aside the sale of the property, alleging many things. She alleged unconscionable bargain, undue influence, sale at an undervalue, lack of independent legal advice, and other things. The parties and their attorneys were present at the case management conference. So for those of you who are on the call, and I hope everybody heard the story of the elderly woman from Central Trinidad. I'll run through it quickly, just in case anybody came in late and did not hear it, did not read or write, couldn't sign her name, didn't speak the Queen's English, which I said was an understatement, very difficult dialect even for me to understand. She was hard of hearing, not in the best of health, short-term memory, very poor. Husband died, leaving her with a son, his wife, and a granddaughter. Little formal education in that family, only the granddaughter had a few passes. Husband had left her with an old property which was increasing in value. And someone came and she sold that property for much less than it was worth, according to her. So she comes to court to set aside the sale of the property. And as we've heard the facts of the case, I want us to start to think, those who are judges on the call and those who are attorneys, those who are from other fields, let's start to think the facts of this case as I have given to you. What are some of the vulnerabilities that you have picked up? What vulnerabilities as a court, as an attorney, would you have to start to focus on and think about? And see how you will deal with them. Let's go to, I hope you're all accustomed to Mentimeter. Um, Judicial Counsel of the CCJ, Ms. Crystal Charles is here with us, and she will take us. Crystal, can I just quickly put it over to you?
Yes, Judge, no problem. Good morning, everyone. So if you are seeing on the screen right now, there is the first question Judge would have put to participants. So in order to answer this question in a more interactive way, you can either use your phone to scan the QR code, which is to the bottom left of the screen, or if you do not have access to your phone right now, you can enter your browser on your laptop and go to menti.com and enter the code that you will be seeing at the top of the screen. For ease, that code is 78792973. Antonio, if you can kindly put it in the chat for me, I would appreciate it. Thank you.
Yes, good morning, everyone. The link to the website for the anonymous responses, as well as the code, has been shared in the chat.
Crystal, will we be seeing the anonymous responses as they come up?
Yes, Judge. So
Okay,
the responses will come up. I don't believe you'll be able to go to the next question until all the responses are in. And you have a limit of 200 characters to enter as your response.
Okay. So we are seeing 0 responses. Is that what you're getting on your end?
Yes, Judge. I
Okay.
haven't seen a response.
I take it people are going across to Mentimeter to record. We've gone through the story and what are the vulnerabilities that we've seen on the facts of this case? What are some of the weaknesses that we will see when this elderly lady comes to the court? You're her attorney or you're the judge doing the matter?
May I say that I've put an answer in, Madam Justice of Appeal, and
Yes.
I'm afraid the screen just simply comes up, please wait, the presenter hasn't changed slides yet.
Oh.
Okay, let me see if I can remedy that. Thank you
Yes.
for that.
Thank you so much.
Not at all.
Oh, wonderful. Yes. Mhm. Mhm. Yes. Inability to read, if I go through them. her age, the age of the woman, her level of education, disabilities, illiteracy, advanced age, and limited education, being unable to read, write, or speak. So that keeps coming up. A party with no appreciation of the issues, yes, age and limited education, communication difficulties, yes, lack of education, capacity to enter into sale agreement. It's very interesting. Capacity is raised. Very, very interesting. Social and educational factors, illiteracy, economic factors, limited finances, illiteracy of the lady, can't speak well, rural. Are there others? These are all excellent. Yes, so we stay with that for now, and we see that these are some of the things that as we go on today, we start to talk about person with disabilities, someone with advanced age, limited education. Her age, she was, did anybody say hard of hearing? Yes, hard of hearing. Couldn't speak well, a rural person, how to understand legal language. Yes, these are the vulnerabilities. Thank you so much. These are excellent. And then we have one other then, because you are the judge or you are the attorney doing this case. And what are the challenges you will face? What you have to do. I've called a case management conference. I'm the judge doing the matter. I've called a case management conference. All the parties, the attorneys are before me. What are some of the challenges we have to face? Oh, taking clear instructions. Excellent. Let's see, what else? Because remember, she has to put in, we have different things to put in. I don't want to say more, but you know, as an attorney, as a judge, what you need. And they're all anonymous, and there are no wrong ones. So be brave and put in, what are some of the challenges? Obtaining instructions and the giving of clear evidence. The main challenge would be the judge ensuring that the litigant understands the claim and court process every step of the way. Thank you. Ensuring as judge that the parties know and understand the issues. Thank you. Not remembering facts. That's right. Remember, we said her short-term memory was very poor. No witnesses or witnesses not coming forward. Yes. Any others? What other challenges? How to do a witness statement for someone like that? Anybody? Conveying your next steps and obtaining as an attorney. Very, very important. Will she remember if short-term memory is so poor that she gave certain instructions? Yes. Conveying your, yes, appreciating as her judge, her vulnerability and its impact on her ability to really engage in the, I'm not seeing the rest, but yes, to engage in the process, visiting the court in person, yeah, and its impact, to engage in the transaction, yes. Yes, all very, very important issues. Thank you so much. I'll tell you that this was a real case. I had to kind of trim it down because it had a lot of other issues, including a sort of fraudulent actions on the part of certain attorneys. But it was such a difficult case to do. The lady did not remember from 1 minute to the next what her answer was. She did not speak the Queen's English at all. And as I said, that was so that the question arose, how did she do the witness statement that she did? Because the witness statement was in perfect English. And the attorney, the instructing attorney, had to go into the witness box to give the court a complete background on how this lady gave her evidence, how she provided the information that came to be in the witness statement. And of course, you couldn't read back the witness statement to her because she doesn't understand what was in it. It was a most difficult case. The other thing about the lady is that she was so certain that she had been robbed of her land, that despite everything, because you remember, she was selling, she did not have her own lawyer. And the lawyer for the buyer said he would provide a lawyer who would give her independent legal advice. And what she remembers, and no matter what happened in the matter, she remembered this, that there was a man sitting in the corner who they said was a lawyer, and that was supposed to be her lawyer. Obviously, this man who was sitting in the corner knew nothing about the transaction, but he had been put there so that she could not say that she had not been given independent legal advice. And as I say, many things escaped the elderly woman, but not that. That they took her there, she remembered who it was, and she remembered what happened in that office. But if the attorney on the other side, as she was cross-examined, and in the words of her own lawyer, she said to him, "Sir, if you tell her on this hot sunny day that the sky is blue because she does not trust you and think you have on the part of the people who stole her land, she will say to you, no." And I think there were a lot of things that came up in that matter, which I believe for me as a young judge, it was the first time that I really had to grapple with a case like that. Is there anybody who has experienced a similar or something that you think we would benefit to hear from and you want to open your mic? Or anybody wants to talk a little bit about what I have said? You have any other suggestions? How could we have done this case, do you think? Just open your mic, let's speak. This is a topic that I think everyone is interested in. And as I said, there's no right and wrong. We're learning from each other. Anybody? Yeah, so I take it that everyone is thinking about it, but the most difficult thing I believe in this challenge was how to get that evidence from the elderly woman. How to get the evidence. And visiting the court in person, I want to put a marker here and we want to come back to that because we will talk about that a little later. Anything anyone wishes to add on this? Anything that I missed that you put that I missed? If not, we'll move on. Again, I know other new people have come in, so we were dealing with an opening story. Priscilla, if you just go back 2 slides, so persons who came in late would see that we were dealing with based on a true event that took place, an elderly woman who had come and who couldn't read or write or sign her name, hard of hearing with poor short-term memory. Husband died, leaving her property located in a rural neighborhood that was increasing in value. And this lady came to court to set aside the sale of that property, alleged unconscionable bargain, lack of independent legal advice, a host of things. And we were discussing through anonymous responses what was some of the vulnerabilities shown and what were some of the challenges that as an attorney or a judge one would face. So as we move on, and again, I say thank you to all of you for being here and for the judiciary and the attorneys of the Turks and Caicos Island, the JEI, for having me. Let's deal with our first vulnerable group. These are people who have for so many years been knocking at our door, so to speak, to be more so that the judicial system, the legal system could become more inclusive to persons with disabilities. And I wanted to say a few things. You would see on the left side of your screen, disability and inclusion awareness guidelines for judiciaries and judicial officers. And these were developed by the Caribbean Association of Judicial Officers under the competent leadership of the Honorable Mr. Justice Jamada. These were developed in February of 2023, and they have been circulated throughout the Caribbean, and they are an excellent first resource if you want to look at this question of access to justice for persons with disabilities. Now, the guidelines were not just developed, like that. There was meaningful consultation across the Caribbean with persons with disabilities and with organizations that represented persons with disabilities. The guidelines are supposed to be and are intended to provide judiciaries with a practical tool for developing and implementing key practices and procedures that promote and secure the rights of persons with disabilities. And all of that in the administration of justice. So how better to improve and secure the rights of persons with disabilities. The guidelines define access to justice, one of our key points today, as a basic and fundamental principle of the rule of law. For persons with disabilities, it means that the judiciaries take all necessary steps to provide fair, transparent, effective, non-discriminatory services that provide access to justice so that persons with disabilities can have their voices heard and considered and exercise their rights, challenge discrimination, and hold decision makers accountable. And all of this on an equal basis with others. So access to justice for persons with disabilities is key. We want to look at very briefly at some of the things because it's a not too big a book, not too big. The guidelines, I'm not sure with Zoom if you would see, but it's something that as a judge, you could go down to court with it, or if you have in court at home from your office, you could have it as one of your key pieces of material. For those of us who like hard copies, for those who like soft copies, it's online as well, and you can obtain it. So that we have, first of all, we have persons who come to the court. Some of them have a physical disability. In other words, they have a physical impairment, what you might call, for example, someone comes in a wheelchair and the physical impairment is obvious. The impairment is such that extra consideration needs to be given for a court hearing. So the person comes, there's a disability that is obvious, the person cannot see, for example. And I wanted to go back because just last night I remember the case when I was a young lawyer. I used to do work for the Legal Aid Authority in Trinidad and Tobago. And a lady came to me who had lost her sight. When she was, before she lost her sight, she could see, and an agreement had been done for her to sell her home. But when it came to the fact that by the time whatever, and she came to the court, she could not see to identify any documents that I had to put to her. In those days, we had the old rules, Supreme Court rules, so that there were no witness statements and stuff like that. She had to go in the witness box and give her evidence. And it was a difficult case to do as a young attorney because I had never seen a blind person in a courtroom giving evidence. So I started to research, and then I saw that what happened in other courts was that the clerk of the court would read the document, and she would identify it by hearing it, and she would tell the court, yes, that looks like that sounds like the document that I had done. And so we have to bear in mind, of course, things have changed a lot now, so that we are more aware and alert to these disabilities, so that a court would be a lot more proactive than in those days. In those days, there were no case management conferences. Just, I think, something called, if I remember the old days, a cause list. I know you all are too young to remember what that is, but there was a cause list, and you simply turned up in court at the beginning of the month, and the judge said, I will do these matters. And there was no looking at who are the witnesses and are there any special needs and how can we accommodate them? Nothing like that. So I was pretty much on my own. Thankfully, I got a very understanding judge who was very keen that justice should be done for this lady. And so we were able to show him the cases, do with the blind person what we needed to do. So you have that sort of a physical disability. Now you have something that we call mental disabilities, very different. And a lot more challenging for the courts. A mental disability is taken to encompass a mental impairment, such as a mental illness, a learning disability, a developmental disorder, persons with brain injuries, whether from birth or through accident or disease, something called a neurodiverse condition, which it would include an autistic spectrum condition, which we know as autism, but it's a spectrum. Attention deficit hyperactivity disorder, the ADHD. And these are the more difficult and complex disabilities to deal with when you're in a court. Because someone who is on the spectrum for autism might display, no two people are alike. There is in my neighborhood a young man who is on the spectrum, and if you're walking in the afternoon, as my husband and I like to, or should be doing more, I should say, he will come down the street, Trinidad, they say, pelting down the street, running. You actually think he's coming at you. He's not. He's just running. That is what he knows. That is how he gets his comfort. He is just running. I know of another little one. He is 3 years old in a pamper, and he can find an escape anywhere. You have a burglar proofing, that's not keeping him back. He is opening the window and squeezing through the burglar proofing. And then he will squeeze through the gate. And he'll be going up the street in his little diaper, holding his iPad. And nobody knows, in the middle of the road. He has that aspect of autism which causes him to want to escape. So that it is a difficult thing. But aren't people like him entitled to justice? Aren't the young man running in the street, should somebody molest him, assault him, shouldn't he be entitled to justice? But how difficult now it is for us as lawyers and judges. How do we do this? And so this today is just a start. For some of you have been involved in this for a longer time, and you are well able, and you could probably teach us some things, and I hope at some stage you'll open up your mics and teach us and share experiences. But these are, as I indicated, things that we need to look at. I just to get myself interested in it because I like Netflix and so on. I've looked at the series Extraordinary Attorney Woo. I don't know if some of you saw it. Those of you who like Korean flicks or whatever they call would like it. But it's about a young lady with on the spectrum who becomes an attorney. But not all persons on the spectrum will be like that. And by the way, the little boy who escapes can say the Russian alphabet back to front. So they are really a complex group of people. And we need to learn about persons with mental disabilities because more and more of them will come to the court. And we have to know how to deal with them and how to deal with them in a way which is fair and just and allows them to make their points, give their evidence, perhaps through an intermediary. That is someone who is a specialist in communication and understands that issue, not just somebody off the street we pick up, somebody who's properly certified and intermediary, so that the Disability and Inclusion Awareness Guidelines will give us a lot of information. But just recently in July 2024, I believe it's the Judicial College in the UK, they circulated the Equal Treatment Bench Book, and I think it is great. I think it should be a constant guide, just as you have your disability and inclusion awareness guidelines, your Equal Treatment Bench Book as well. And so we want to talk a little bit more about what we should keep in mind when we're an attorney, when we're a judge, sitting in a case where there are persons with disabilities. And the first things we want to understand is that persons with disabilities say that they feel disrespected when they come to court. One person said that when he came to court, they tell him, oh, you have a disability, use the ramp. But he said he could walk. That was not his disability. But they didn't know. And in his view, they didn't care. They didn't care to know. So they tell him he has a disability. Well, go up the ramp. That is a fix for that's a one-stop shop right there. Everything in the ramp. And he said, but that did not help me because I didn't have that kind of disability. Another person said, they don't listen to you. If you don't look and speak and sound the same way, they don't respect you, they don't listen to you. And another one said, I couldn't hear. So I sit down in the court and they say the magistrate calling my name, but I can't hear. And it's my people in say, say, look, they're calling your name, And then of course it sounds like the person is disrespectful to the magistrate, but the person said, I just couldn't hear. And nobody took the time to say, well, this prisoner can't hear, so he needs ABC. So one of the things I wanted to, and I should have mentioned it earlier, is I am using the term persons with disabilities. And that's the term we use in Trinidad and Tobago. I see that you have a disabled persons ordinance, so you seem to be using a different term, which is disabled persons. And what we realize is that the terms vary from jurisdiction to jurisdiction. So you use the term as an attorney, as a judge, which best is used in your jurisdiction. In the Equal Treatment Bench Book, we see that they say that the proper term is disabled. If you say that in Trinidad, they would say you're calling them disabled. They're not disabled. They say they're a person first and they have a disability second. So you just have to know what is the respectful language. And there is something that I wish you to take a note of. If you're taking notes, there's disability inclusive language guidelines. And these are published by UN Geneva. Have a look at those. They're referred to in the Disability and Inclusion Awareness Guidelines, and they're very useful to tell you how to refer to the disability and to the person with the disability. Now, that's the first thing. Be respectful when you refer to people and so on. The second thing is training. Persons with disabilities told us doing the work that we did that everyone needs to be trained. Because remember, the first person in the court that people meet are whom? Antonio was the first person we meet when we go up the steps of the Hall of Justice, for example.
I would say you'd be the security. That's the
That's
first
right. That's the first person to train, because they say, you know, the security say use the ramp if you have a disability. So everyone needs to be trained. Everyone needs to understand that this is about justice. It's not about doing a favor to somebody. This is about justice. And then we want to recognize as well that people have multiple disabilities. You may not just have one, you may have multiple ones. And the other thing we want to recognize and keep in mind is the intersectionality of disability and other inequality barriers. So you have barriers such as age, because you saw the multiple disabilities with the opening story with the elderly lady. She had multiple disabilities, but then you saw the intersectionality with rurality, age, gender, language, yes. So in the guidelines, the disability CAJO guidelines, they describe intersectionality as the way in which disabilities and inequalities interact with each other. And I often, you know, think about this. It probably is a little of an exaggeration, but you think about a person with a disability who has been raped. She lives in a rural area. She does not speak English well. In fact, English is not her first language. And she's also a migrant. So think about that intersectionality. Or she may be not a migrant, she may be an indigenous person. And often we're dealing with inequalities and vulnerabilities and disabilities, which are all interacting, intersecting, and we have then to come up with not just one little, we don't just have to talk about the blind lady or the lady who couldn't hear, but we have now to talk about all these vulnerabilities and what sort of plan can be put in place, what arrangements need to be made, what accommodations need to be made, what support these people need, because they got to give. We have to find ways for them to give their best evidence to the court. And then, of course, we want to be sensitive. Someone mentioned to me that there are certain persons with certain disabilities will not tell you they have a disability. I don't know if you've ever sat in court and seen people go to the bathroom every minute. And that is an incontinence, and persons will hardly say to you. You see it in church as well. People sit near the door so they can run out and come back. And then so I say, what is in and out, in and out, in and out, until it happens to us one day. Because someone said to me, Maureen, if you live long enough, you will have a disability. I think we need to keep that in mind, to be sensitive to the fact that not everybody will acknowledge that they have a disability. We have to find respectful ways to try to get these things out of them in a way where they realize we're really doing it for their good, not to embarrass them. And again, with sensitivity, we need to look and design practical solutions, because what we're looking at is making a process which is fair. Fairness of the trial process is key. Now, you're dealing with a person who has is in a wheelchair. Can I ask what if any, accommodations in the hearing of the matter that you might want to make? Can you open your mic and give me some suggestions, please? A person's in a wheelchair, you're doing a trial, you're taking evidence, and the person comes physically to court. Anybody? Or you want to put the ideas in the chat? Somebody says adequate seating and elevation. Yes, yes, I like that. Is I'm trying to look at the name, access to the witness box. Can I ask the adequate seating and elevation? Could you open your mic and tell us a little bit about what you have in mind there? Mr. Brown? Oh, your mic's not working. Okay, that's fine. But I wanted to say something about that because all the other witnesses where I used to be and where I am now go in up a step and they sit in a witness box. But the person in the wheelchair cannot go there. And they have to give evidence from the bar table at the end. And you have to make sure the mic comes to them. And it never to me seemed right. That there wasn't anything that I could do about it because that's how the courtroom was. But it never seemed to me that anybody looking would think everybody was on an equal footing. I don't know if you catch what I'm saying. And then somebody saying access to the witness box. Well, Jasmine, they can't really get in. Did you have something else in mind? Jasmine, open your mic if you can.
Hi, good morning, Judge, and good morning, everyone. I thought about this because I know recently I would have visited the new waterfront court in Port of Spain. And the witness box is actually, to get into the witness box, there's a little ramp versus the step up as usual. So that's what I thought of I didn't think about the ramp being accessible to wheelchair persons at the point in time, but as you brought it up, Judge, I thought about, oh, well, no, the ramp is so that they'll be able to access the witness box to give evidence.
Thank you. And thanks so much, Jasmine. There's someone says access to the courtroom first, because we know in some courtrooms, they cannot get, the courtroom is on the second floor or the first floor, depending, we call it differently. And the person can't get up because they're in a wheelchair. And we don't have a problem getting some big burly security people or the family to lift them up. But the persons in the wheelchair tell us that that's very demeaning. They don't feel like a normal person when you have to lift me up like a baby and put me down and everybody watching me, you know? So we need to start to rethink how we make courts, how we design courts. Miss Ferguson said, make concessions with respect to change in the usual witness box seating, like have them placed in the well of the court. Yes, that can work. We have to look for ways because, and then somebody said, use of video link to take evidence, allow easy access, and also take away the view of the wheelchair from a jury who may be influenced by it. And of course, now when many places, and I imagine you all are no different, you're using a lot of video links, you're using a lot of online court. There's a big online court movement so that a lot of people, I am not sure, and I really would love a conversation about how good that is for an old person or for a person with a disability who can't see. They have to go through a lawyer, sit down in an office. Here, I imagine what is coming through the computer, and hopefully the quality is good. And then to answer questions in cross-examination. I am just not sure. I don't know anybody has a view. We'll come to it when we deal with it as a question, but I want you to start to think about it. A person who is, it might be best, for example, a person who's autistic or a person with an attention deficit disorder. They can't stay quiet. I have a neighbor who was a principal at a school, and she told me there's some girls at the school that are suffer so much with attention deficit disorder that they have to let them stand at the back of the class. They can't sit during class because they can't pay attention like that. They're bright and they're intelligent and they're doing well, but you have to understand their needs. So if we had somebody like that who needed a, it's difficult. I'm not sure that the courtroom that is online is completely suited to all persons with disabilities. But again, that's something that I can leave with you for when you decide that you want to do, take the disability guidelines and make it your own in the TCI if you haven't done so yet, and start to think about these things. And then someone says, Macmillan, ensuring the courtroom is wheelchair accessible and that there's a space for a wheelchair to maneuver in the courtroom with ease. Yes. So those are some of the things that we want to think about. We want to think about, as well, as I mentioned, somebody in a wheelchair. You want to take shorter breaks. You don't want to take too many long sit. You might want to sit for shorter hours to accommodate that person. Can that person in a wheelchair or a person who suffers with some sort of mental impairment, hard of hearing, like the elderly woman in our story, can she be cross-examined for a whole day? Things like that, we have to start to think about, should we take more breaks? Should we allow them to take the person in the wheelchair to the bathroom? Will they be in pamper? Will they be in diapers? There's so many things that we need to think about. So because another thing I thought about was that, but anyway, when we come to another section, we will also deal with that aspect of perhaps not, so we want to sit short hours. We want to take more breaks, more frequent breaks. That's another aspect. Another aspect we want to look at is the procedural accommodations. And these are the things we've been talking about. What adjustments, what appropriate modifications we want to make. I want to read this. In some cases, intermediaries are utilized where vulnerable witnesses are testifying virtually. Yes. They ensure that the witness is controlled and kept comfortable, and that is so important. They also communicate issues to the court as they arise. Yes, this works in cases of vulnerable witnesses suite so that they manage the suite while the witness, uses the suite from where they are testifying via live link. So yes, these intermediaries, and I think we mentioned before, these trained and approved personnel who are communication specialists, but also specialized in the particular disability, they are there to ensure that the witnesses can give their evidence, that they're comfortable. If something has gone wrong, they will communicate that to the court. And then another one, during case management, you will decide what are the most suitable adjustments based on the individual case or vulnerability. And that's so important, the case management of these matters, both criminal and civil. How are we going to get the best evidence available from all the witnesses, not just the persons with disabilities, because the trial process has to be fair. And this is where the procedural accommodations come in. What adjustments can we make? Thank you so much for these excellent responses and experiences and suggestions. Thanks for sharing. For example, you have someone who is blind, but you want to be sure that the person understands how the process is working. Normally, there would be notices coming from the court or things, on the website. That person cannot access those things. So you want to ensure that the attorney knows, and this is where the attorney has a very serious obligation to ensure that you sit and speak to your clients respectfully, and that you too understand all that we're talking about. Because as with me, and as I mentioned with that blind lady, who from legal aid, so I had to do it. I had to ensure that she had a fair hearing before the judge. And it would require extra work, I can tell you, because to do a witness statement for someone who does not see, as you know, you have extra obligations as an attorney to ensure that all you put in is what she has said, so that we all have a responsibility in this area. How do you ensure that a person's hard of hearing can give evidence, can hear the cross-examination? And that is another aspect. And it doesn't answer that to say everybody will say, two things I want to say about the hard of hearing. They may not tell you they will. You will just hear them speaking very, very loudly or telling you what, they don't necessarily tell you that they're hard of hearing. And then the second thing is that it's very difficult now to ask them a question, because you're not sure what they heard. What was the question that they heard? And you hear an answer that came out, it suggests you, but that's not what was asked. So there are a lot of issues that are for you as a lawyer and as a judge to deal with. I may have mentioned before, and if I did, excuse me, but I remember when we were dealing with that case, the lawyer made the point that the lady was so hard of hearing that when she came to our office on several occasions to do the witness statement, to give the instructions and do the witness statement, that she could only do it in short bite-sized pieces then, because she couldn't go along with the lady, one. But two, the lady was so hard of hearing that she had to keep shouting, and the whole office could hear, even though she had her in a conference room. And the whole office could hear, and every time the lady left, she was like exhausted as the instructing attorney. And then, of course, the last thing I want to say is that not everybody understands sign language. So to say, well, if you're deaf or you're hard of hearing, sign language, no, it doesn't work so. Some people know it, but some don't. So sign language is not an answer for all who may be hard of hearing. So we want to wrap this part up by looking at first of all, the CCJ, RJLSC, a draft policy for access to justice and to provide accommodations for persons with disabilities. This is in draft, as I mentioned. It's up for the approval of the RJLSC. And it's our president, Honorable Justice Adrian Saunders, when we were invited to a conference hosted by Impact Justice at the Hilton, probably about 2 years ago. And coming out of that, he and I spoke, and we thought we could not but have a draft policy. How do we improve access to justice? And not just for people who come into the court, but for our internal users. What should happen if a person who's administrative officer at the court should get in an accident and be in a wheelchair? Did we have a policy as to what should happen when they had to return to work? So we have that, and we've consulted far and wide with it. judiciaries, bar associations, persons with disabilities. And remember, if you're going to undertake work on this matter, the motto of all persons with disabilities is nothing about us without us. Nothing about us without us. So we need to involve them every step of the way. And so to wrap up this aspect, I want to refer to quickly the CCJ case management checklist. Not every matter we sit in a case management conference for. Some matters that come to us, we send out checklists, which would contain more or less the information we need. And we have recently added to that checklist, do you have any special needs? Do you wish us to provide any special accommodations for you or your clients? And the last aspect is that keep in mind that at the CCJ, we now do sign language for all our judgments so that persons who know sign language, and that would include our deaf community, they can come on and follow. And additional resources, as I mentioned, you have a disabled persons ordinance, and that provides for the protection and care of disabled persons in the TCI. That is an interesting ordinance, and you'd want to, I'm sure you know about it. And then the criminal bench book for magistrates and parish court judges in the Caribbean, developed by the Jurist Project under the wonderful leadership of the Honorable Mrs. Justice Alice York Suhan. That bench book for magistrates and judges also available online, and that contains some excellent suggestions for vulnerable defendants and witnesses, and that includes persons with disabilities. So thank you so much. We'll pass on to our second vulnerable group, and it's something that I wanted to talk about. You know, as you get older, I don't want to laugh, but believe me, I'm in that category now. As we get older, we go into a group of persons called the elderly, seniors, you know, persons who, for some reason, we forget. And the UN, United Nations, through the World Health Organization, has declared 2021 to 2030 the decade of healthy aging. And healthy aging is not just your physical health, but this involves focusing on changing how we feel, think, and act towards aging. It's a global collaboration, and it addresses the challenges faced by the elderly. It emphasizes a human rights-based approach, better access to long-term care, and mental health support. It is notable that age discrimination in employment is being outlawed in many jurisdictions. And I wanted to refer here to the Equality Act of the United Kingdom of 2010. So certain things like you're too old to be promoted. I heard that recently somewhere, that if you had reached a particular age, you couldn't apply for a particular job. Well, those things are being outlawed. Those things, in any case, even if they're not outlawed, how is that? How does that fall within what we have been talking about, a human rights-based approach? It's just like saying you're too young for something, you know, for recruitment, those things. And even in some places, I think Australia may be one, where you can no longer be forced to retire at the mandatory retirement age. You choose when you wish to retire. Of course, there are guardrails and there are things that are put in to ensure that the law is fair to the employer as well. But this is all in an effort to protect the elderly against discrimination. And we want to look at that because the elderly have distinct human rights. that is something we need to keep in mind. Distinct human rights, but they face so many challenges. So many people say, well, Granny getting old and she don't remember this and she don't remember that, or that is not true. She's suffering with Alzheimer's. So nobody stole her money when people were stealing her money, and we just would not believe her. We would not believe what she said because why? Because she getting old. And so we have a whole group of people who are getting into that group called aging. Yes, thanks very much. This is the book we were talking about, the Equal Treatment Bench book. Excellent, excellent. Because we discriminate against the elderly due to stereotypes and prejudice based because of their age or cognitive decline. But because they are declining cognitively doesn't mean that they're not speaking the truth, or they don't know what's happening to them, or they don't know their money is missing, things like that. So um, we've got to step back, I think, when it comes to the elderly, and consider whether we're really giving them a real access to justice. And of course, just as we were talking about with intersectionality, we must remember that the elderly also face that because they may not have education, they may not understand this new IT world that we're so comfortable with. You all are all there and you were able to go on to Mentimeter. If you mention that to your grandmother, she would be like, mentor what? I remember the first time my mother-in-law was told, well, a mouse? But we know what it is. We know there's a whole new world out there that IT has brought us into, the digital world that the elderly know little about. And that's why some of them on a Sunday morning, as hard as it is, would still prefer somebody come and pick them up and take them to church. But other people happy with the Zoom, they're still on Zoom church. So we have to remember the elderly face barriers. Some of these barriers, again, to go back to those, could be lack of education, a language barrier, like the elderly woman in our story. Some of them no longer have the partner they've had all their lives, so that they feel a bit lost. And now they have children. The children may not be here, they may be abroad. Who looks after them? Who is their caregiver? There are serious issues. But then we must bear in mind as well now that the elderly too must have access to justice. One of the greatest violations of their human rights is something that we could call elder abuse. And I'm sure you have seen it worked out. You've seen neglect by family members. They're squabbling over property and money in the bank, and they want their name on the bank account, and they want this and they want that. But they're not taking care of the elderly person. I remember a case like that came to court. And someone came and suggested to me that the elderly lady was not being taken care of at all. And speaking to them, got them to agree to a consent order that they would take the person to a doctor. And the doctor's report, well, I don't know when last this person was seeing a doctor because their health was in a mess. And so as when we have the opportunity, either as a lawyer or as a judge, we need to think about, is this person just being used so that they could get money out of the person? There are some elderly where they sign over their pension to whoever it is, a son, a daughter, whatever, and they never see the money. The pension doesn't manifest in food or health care or any kind of care for the elderly person. I imagine you have the Mental Health Act of Trinidad and Tobago the way we do. Sorry, you would have a Mental Health Act the way we have it in Trinidad and Tobago. Or you may have another act which allows a person to come to the court, and we talk about the elderly, so I'll mention the elderly. I'll keep it there. The person is now so old, they have declined mentally, and so they're not able to see about their affairs and their property, so that a person can come and apply to the court to become sort of like what we would call a guardian, or someone who could take charge of the affairs and property of the elderly person. And what we have observed, and I don't know if you all have seen it in the TCI, is that that is often a fight to get the elderly person's property. That is a way to get control. So what happens is that they are, and I want to use the word, arbitrarily detained, some of our elderly, in old people's homes or in long-term care facilities, when there can be independent living arrangements, and they can stay in their own home, because many times that is their home. They're not by a family or anything, but they fight over them, they get control over their property, they sell it sometimes, or they put the old people in the home, and they do what they like with the property and with the money. And when those matters under the whatever is equivalent of the Mental Health Act of Trinidad and Tobago in the TCI, when those matters come before you, I want you to put up a red flag and see how best you can get independent reports on the state of the health and of the affairs of the elderly, because often you will realize that the people don't have the elderly in mind. And in Trinidad and Tobago, often the report is served on the public trustee, and the public trustee has a division and so on where they can do reports. I have also asked the director of aging, who operates under, I believe, the Ministry of Social Development. I have asked the director of aging to become involved in some of the matters. I had a case where this elderly lady from South Trinidad, she had about 10 children and like 2 camps, and 5 on one side, 5 on the other. And they were all fighting, and I remember they called her mama, so I called her mama. And I mean, the thing with mama is they bring her in the court, poor mama don't have a clue what is going on. I said, Mama, you want to leave your home and go somewhere? She said, no, I don't want to go anywhere. I said, Mama, what do you want? I don't know, I just wish they would stop fighting, this kind of thing. The poor lady, it really was it was not a nice thing to see at all. And so when we have to deal with those matters, we have to hope that the lawyers who come be as concerned as the court should be about the welfare of these persons. And so the last thing I want to say is that the elderly are also entitled to this, and it's a human right, and that is the right to an expeditious court hearing. And those things can be found in some cases that I found from Poland against the Polish government, where the elderly's cases were left there, just taking its own sweet time through the court. And if you're 80 and you come to the court, you don't have much time. So you want to make good use of case management to ensure that you kind of put those matters to the top of the list, so you can do certain things. In our case, going back to the opening story that I gave, what we did, we put the elderly lady in the court first. And we took her evidence and all the cross-examination. We went to 2 days and we did it. The other parts of the case were still being prepared, but the attorney was concerned that the elderly lady might have a stroke or something because she really was not in good health. So we took her evidence first and then we adjourned. And then probably a couple of weeks later, we began the case again, and took the rest of the evidence. Even things like the opening statements and all that we took after. So these are the things I wanted to mention about the elderly. But I wanted as well, before we go on to that, before we go on to our third, remember I mentioned it earlier, should we use remote hearings for the elderly? What do you think? Is there anybody who, we were talking about that with persons with disabilities? What about the elderly? What do you think? Can anybody open their mic? And if you have a mic that is working, or put it in the chat. What do you think? What are the pros and cons? That's what I wanted us to talk about.
May I? It's Andrew
Yes.
Mitchell here
Yes,
speaking.
certainly.
I think the issues with the elderly fall in both directions. One, having them able to appear as witnesses in court from home saves them the inconvenience of travel. But on the other side, there must be some concern as to how they may be affected or influenced by people who are not on camera. That part of it is obviously of some concern, even for witnesses who are not elderly. And I just wonder whether having the witness represented by somebody who is disinterested in the process, but can confirm to the court that everything is in order, rather like at the start of the process with vulnerable witnesses, when the vulnerable witness would sit off camera in another room. There would be an usher to confirm that everything was all right. I imagine that if we could find a way of somebody from the court service or something like that being with the elderly person, that would give comfort to the parties and the court that everything was all right. And therefore, having talked it through with you, I rather come round to the view that yes, we should be making facilities available for the elderly to give evidence remotely, but with some sort of safeguards in place.
Yes, I like that very much. And I think, yes, that is an excellent idea. And I think I mentioned the director of aging. I imagine there are people like that in the TCI, or some other court facility, some other person who works in the court. But that would be useful because you would want that person to be there throughout. You wouldn't want that person, I imagine, to just be there to ensure that at the beginning. Yes?
I
Yeah.
absolutely agree with you. And in fact, just developing on your theme, if I may, milady, that is very much a case of the courts now learning to outreach. And so the facilities of outreach are important, and maybe that's something to be considered.
Yes, yes, certainly. But there is room as well for the elderly, and some of them would prefer not to look into a camera or a screen, and there should be room for us to be able to accommodate them in the courtroom. Some of the things we want to bear in mind with the elderly is that some of them suffer with high blood pressure, diabetes, heart issues, and I've always noticed that sometimes we take the elderly as witnesses without asking, have they eaten? Something as small as that. It's 12 o'clock, and for me and you, we could go another hour or two. But for someone who left Princestown in South Trinidad, 4 o'clock this morning, to come up to Port of Spain, probably eat a little something, a doubles or something, and to come in, 12 o'clock, they're going to be hungry. So I want us to start to think about that. And even if it is that they haven't traveled, but they have been waiting to be called as a witness online, I think some of the questions, before they come into the court, do they need a bathroom break? Do they need to go and eat? Just to ensure that we are treating them fairly, one, and two, that we're going to get the best evidence out of them. But I like the idea of how we could use remote hearings. Is there anyone else who wanted to open their mic and speak? Thank you very much. Anything in the chat? Any experiences that anybody wanted to share? Yes. Just remember what my friend told me. Maureen, if you live long enough, you will have a disability, but not just that, I can tell you, you'll become elderly. So thank you very much for the interaction in this second vulnerable group, the human rights of the elderly. And we go on to our third vulnerable group. We want to look at gender-based violence. We want to look at the victims slash survivors of gender-based violence. We want to look at a rights-based approach to gender-based violence. And we want to recognize, first of all, gender-based violence is a really harmful acts directed at an individual or group of individuals based on their gender. It is rooted in gender inequality and the abuse of power and harmful norms. We want to also recognize that while women and girls suffer disproportionately from gender-based violence, men and boys can also be targeted. And the term is also used to describe targeted violence against LGBTQI+ populations. So in other words, few, if any, escape. I saw recently some statistics on gender-based violence, and I saw some statistics on sexual offenses. I think it was in Guyana, and it's very worrying. One of the, I know many of you know about the Jurist Project, and you would know as well that there were many aspects to the Jurist Project, but one of the most important components of the Jurist Project looked at this area of sexual offenses, gender-based violence. And in 2017, model guidelines for sexual offense cases in the Caribbean region were developed. I was privileged to chair the committee that supported the development of those guidelines. And in 2022, we revised those guidelines. And they really offer, as I mentioned before, a rights-based approach to the treatment of complainants and vulnerable witnesses in sexual offense cases. And they really highlighted best practices for the management of such cases. And the guidelines use as guiding principles several international conventions, such as Belém do Pará, other conventions that looked and dealt with the violence, the elimination of violence against women, like CEDAW and so on. So the guidelines are an extremely useful guide. Another, if you're doing sexual offense cases, you want the guidelines to be another resource that you would look at. I want to mention a few things about the guidelines, because before the guidelines were done, we did a lot of work going out to consult with people. We consulted with over 200 persons who have interacted with the justice system and who were survivors of sexual offenses, whether they were children, they were adults. The most grievous matter that concerned them issue was delay. Delay. It was simply terrible that some persons, there was a case where the person had been raped at age 16 and at age 27, now married with children, she was having to be called to give evidence. And she just said to the judge, I'm not interested in that, I'm not going on in this case. So those are some of the things that we found when we dealt with when we had our consultations, how delay impacted so negatively, especially in this field of sexual offenses. So we'll come back to discuss that. But the guidelines had certain aims. We wanted to improve public confidence in the justice system. We wanted to improve the court's response to these victims and survivors so that they could participate fully in the justice system. And at the same time, how could we reduce secondary victimization? Those were some of the things we looked at. We wanted to ensure that there was a cadre of trained and skilled professionals who could could respond efficiently to sexual offense cases. And these were not just judicial officers, because when we had our consultations, we dealt with doctors, nurses, police, prosecutors, defense attorneys, court staff, registrars, magistrates, judges, parish court judges. So that those were some of the things that we wanted to ensure that there were trained people dealing with these cases. We also want to ensure a speedy adjudication of cases, as I mentioned earlier, and a reduction of backlog, because we felt that was a serious issue. And so in setting out the guidelines, there are many good parts to it, and I recommend a study of it. But some of the key things were proactive case management. Proactive case management to eradicate delay and reduce trauma. The second thing, the early identification of vulnerable witnesses. And 3, the use of special measures to ensure that the best evidence is given by vulnerable witnesses. In addition to all the very good things the guidelines set out about vulnerable witnesses, how to identify them, who may be a vulnerable witness, and what special measures can be devised and used with vulnerable witnesses in sexual offense cases. The guidelines also contained measures, recommendations for survivor care and protection generally, so that the use of support persons for survivors, as well as the interaction again, the intersectionality with persons with disabilities, with indigenous persons, with children. Because, for example, in some places, a lot of these sexual offense cases are against children. And so that was a key aspect of the guidelines. When we had our consultations, the police officers asked us for guidelines for them. And so the guidelines also contain police forensic interview guidelines, how to speak, how to ask the questions, the right questions. And of course, a lot of the police services now throughout the Caribbean have a special designed designated unit for sexual offenses, special victims unit, with really well-trained police officers taking that evidence and taking the statements Or with the case of children, for example, in Guyana, Blossom Inc. or Child Link, they have arrangements with the police where the police officers come to their places and they take the evidence. It is recorded in these places, and the persons who do the interviewing of the children are properly persons who know are specialists in that field of getting the children how to answer, what to put. And these things are what you would call video taped, so that the child doesn't have to repeat the evidence all the time. So there are a lot of good things going on in this field. You would know that we set up through the same project, model court for sexual offenses in St. John's, Antigua. When the Chancellor of Guyana, the Honorable Yonette Cummins, heard that we were doing this, she began her own sexual offenses court in Guyana, and Guyana now has 3 sexual offenses courts, which have reduced the backlog greatly. And there is such public confidence in it that reporting of sexual offenses has increased. And that is something that is important, because sexual offenses are such an underreported offense. So those are some of the things I want to tell you about the guidelines. I recommend them highly. The police forensic interview had a special focus on persons with disabilities, indigenous persons, because both in Belize and Guyana and other parts of the Caribbean, we have indigenous people. And then we also focus on children because of the number of sexual offense cases that, against children as victims. The guidelines also have good references to victim impact statements and their importance when a judge is doing sentencing, so that the victim's voice can be heard as to how this has impacted on them. That is one aspect. And then I've put 2 cases from the CCJ that I recommend highly that you read, and they are also included in the guidelines. Linton Pompey, which involves the rape of a 14-year-old, and Calvin Ramcharan, which involves the rape of an adult woman. So it'd be interesting for you to look at those, to see how the CCJ has been dealing, and the things that we have said about the importance of sexual offenses and how they're dealt with, how we deal with them in the court, and sentencing, really, both of them concerned sentencing. So I leave those with you. I also wanted to mention that you have in the TCI, as you're aware, vulnerable witnesses. I believe it should be, we miss an E and an S at the top, but that's all right. A vulnerable witnesses ordinance, chapter 216, witness eligible for assistance on grounds of age or vulnerability. In other words, who are your vulnerable witnesses? And according to section 3 of your ordinance, if the person is under age 18, and that's what we would call a child in Trinidad and Tobago, or if the court considers that the quality of evidence given by the witness is likely to be diminished by reason of any circumstances falling within section 2. So subsection 2, these are, again, suffers from mental disorder, has a significant impairment of intelligence and social functioning, or is otherwise vulnerable. The witness has a physical disability or is suffering from a physical disorder. So I think this demonstrates so beautifully the intersectionality that I was talking about. That there you have a rape victim, but the person also has a mental disorder. This is a person who requires special accommodations, these procedural accommodations that we were talking about. And I'm hoping that as we go through this, that other persons will open your mic or put in the chat any experiences, any best practices, which is what the guidelines seek to include, their best practices. So we go on to section 4 of the same ordinance, of your ordinance. You have now witnesses eligible for assistance on grounds of fear or distress about testifying. And there are a host of circumstances, the nature and the alleged circumstances of the offense, the age. And when I saw age there, I thought of the elderly. Such of the following matters as appear to the court to be relevant: social and cultural background, ethnic origins, domestic and employment circumstances. And you could see the poverty and other things there, any religious beliefs or political opinions. And of course, under ethnic origins, you would have like your migrants and your tribal and indigenous peoples, your rural people, and so on. Any behavior towards the witness on the part of, so that's another aspect of fear or distress about testifying. I've looked at your ordinance and it's very well done. It's very comprehensive. I just wondered how it's working in the TCI, and I wondered whether there was anybody on the chat from the DPP's office or the AG's office or the judge doing these matters who could share how has this worked, and then you will have several aspects of special measures that can be employed for vulnerable witnesses. Can you share with us, please? Nobody from the DPP's office or Crown, probably I may have the name wrong, but the prosecuting authorities or the judges doing these cases. How is this working? And okay, anybody wants to put anything in the chat, because this is it's important for us not just to have the laws, but to see them operate and to be able to say, yes, well, we did X and Y and so on, and we were successful, or we learned this lesson from it. So anybody at all? By the way, as you think about it, the guidelines also have an entire chapter on if you wish to set up a sexual offences court yourself, what are the things that you'll need? So I recommend it to you. I believe it's the last chapter of the guidelines, and it pulls from the sexual offences model court, which was set up in Antigua and Barbuda in St. John's. And of course, there's no perfect situation. As you know, everything was impacted by COVID, and a lot of the courts are still catching up with backlog and so on. But it is an excellent idea to have a sexual offences court, or at least a court that is where everyone concerned is trained in this area, so that persons who come to court are really able to feel that they have not been excluded, they're not being re-victimized, they're not being re-traumatized, and that is the whole idea of it. And so I want to talk about briefly some cases that have recently come to the courts of Trinidad and Tobago, and one from the CCJ. And I am just fascinated with some of these cases. The ones from Trinidad and Tobago, the first one was Tot Lamkin. against the AG. A fascinating case. It's on appeal. It's judgment of Justice Mohammed, Robin and Mohammed, and it was given this year, and it made a lot of news in Trinidad and Tobago. A mother filed a claim for constitutional redress. Her daughter had suffered a tragic and violent death at the hands of her former partner after a sustained campaign of domestic violence. The daughter left a son who would be this lady's grandson now. And this lady came to court complaining of the failure of the police service to take appropriate and necessary steps to address the violence complained of. She said her daughter was not provided with adequate and effective protection, despite several reports made to them concerning his conduct. And they also complained of the failure of the judiciary to provide timely and effective relief and protection to the daughter, despite her application for an interim protection order under the Domestic Violence Act of Trinidad and Tobago. A really interesting read. Read it from the point of view of the mother and of that child, of the girl who was killed. The trial judge noted that the mother's claim stood on the submission that the state had a positive obligation to exercise due diligence to protect, to prevent, and investigate acts of violence committed by non-state actors. That is what the former partner was, a non-state actor, and to ensure the due punishment of perpetrators and the provision of redress to victims. The mother was successful in her claim. The trial judge considered that she ought to succeed, having regard to the exceptional facts of the case. And he said that it warranted a novel interpretation to the fundamental rights that had been relied on. There was therefore imposed on the state positive obligations to act with due diligence to protect an individual's enjoyment of their fundamental rights from being violated by the actions of non-state actors. And I have several paragraphs here, but I don't think I will call them out. I will just encourage you to read this case and read it with a different focus. Focus on how the magistrate addressed it. Focus on what the magistrate could have done differently. I think I've read so many of them now, but I think this is the case where the magistrate accused the young lady when she came to court of only coming to court because she wanted maintenance for the child, that there really wasn't any domestic violence. And there had been so much real violence, physical violence, that one wondered, how did that happen? And I think it really, you could see Justice Mohammed's emotions arising, so to speak, when he recounted the things the magistrate said to the person, the applicant, when she was trying to get the interim protection order. So read it with that lens if you're a judicial officer on the call. The second case, of course, I think you all know it because last year several of you were here, and Justice Jamada dealt with it on statutory interpretation or constitutional interpretation, and that is a domestic violence case from Barbados that was dealt with last year by the CCJ, and the question in OO against BK was, did the applicant woman who applied for a protection order, was she a former spouse under the domestic violence legislation of Barbados? And again, I want you to read that case and look at it with a different eye. Look at it from the point of view of what the magistrate or the Court of Appeal of Barbados could have done differently, because the magistrates had one way of doing the matter, which we frowned on at the CCJ. The Court of Appeal thought it was right. And then when it came to the Court of Appeal, the Court of Appeal itself had its own spin on what had happened before the magistrate and what leg could the lady stand on. Was she a former spouse? So it's a very, very interesting case. And I like to look at those cases, not just from the legal point of view, the law, because we could all get the law wrong. That has happened to all of us. But what we shouldn't get wrong is fairness and how we approach cases and how we deal with people in a fair and just manner. I think that is key to everything that we do. So I encourage you with OO and BK, but another fascinating case has come out of Trinidad and Tobago again. And this one is FR against AG. And I suppose you realize that with Trinidad and Tobago and with OO and BK, we are anonymizing these cases so that in Trinidad and Tobago, there's a whole unit in the judiciary that looks at how to anonymize all the judgments that come from the family court, the children's court, any other court that deals with matters concerning domestic violence and children's matters and those things. So in this case, FR against AG, Justice Quinlan Williams, she anonymized it by order of the court. In some places, I know at the CCJ, we are in the process of developing anonymization guidelines to guide us for cases, for example, that come to us. They come to us with the names, but we are anonymizing them. That's what we did in OO. And then last year, we also had a case of a child and a sexual offense, and that is BK. Not BK, I'm sorry, AB. So that that is an important aspect. So we have here FR, again, as I said, this person was an alleged victim of rape at the age of 16. She claimed, again, under the Constitution, that she had fundamental rights had been breached because of unreasonable delay. Just what we were speaking about earlier in the trial process. The trial judge decided in her favor and made a declaration that the failure of the state to ensure that matters involving children were expeditiously concluded constituted a breach of the constitutional rights of child victims. Very interesting, I must say. The Court of Appeal has reversed that decision, and from what I understand, that most likely will go to the Privy Council. The Court of Appeal's basis for reversing was that there is not in Trinidad and Tobago, as in other places, a right to a speedy trial or trial within a reasonable time. Again, I'm not about whether the case is right or wrong, but I just say, read the case from the point of view of the trauma caused to the victim, to the survivor, the complainant, where there is that kind of delay, so that we understand, we begin to understand how important it is for us to get things going in this field. And the last thing I want to talk about was the CCJ, and under this group, the CCJ RJLSC harassment policy, which was approved in 2019. It is at the CCJ any matters concerning internal, even our external users, people who come to the court. Everyone has a responsibility not to harass. Harassment here involves bullying, disrespecting, sexual harassment. All those things are in our harassment policy, and this is an extremely important aspect at the CCJ, that where the court itself can set down a marker and say, look, we stand against these things, And we think it's important enough to put it in a policy. And it applies to all judges, all managers, all staff, all commissioners of the JLSC. It also applies, as I mentioned, anybody who comes to the court. So an attorney coming to the court from outside cannot bully, disrespect, or in any way harass sexually any of the persons they meet at the court. So those are important. I hope that this has been useful to you. And in the short time that I have left, because I want to leave a few minutes for any questions, I want to talk about this very, very important fourth vulnerable group, migrants and asylum seekers. Wow, you talk about complex. You talk about what's the answer? Where do we go from here? How do we approach this? How do we change people's minds so they think and understand that these people also are vulnerable and require and have human rights? How do we get a rights-based approach to how we deal with this? And I wanted to say that it's not just in Trinidad and Tobago, where according to the UN, we have some 38,000 Venezuelans. If you live here, it feels more like 100,000, and you wonder if the statistics are correct. You know, every community, north, south, east, west, and Tobago, people have come in from Venezuela because of the situation there. Because what I read is, as of, I think it was sometime not too long ago, there was some 7.7 million Venezuelans who have left Venezuela in the last few years. So think about having to leave your home, everything you've built, all your family. So as people leave their mother, they leave their old granny, and they go on a boat, and they come here seeking a better life because they can't get medication, they can't get treatment, they can't get this. Those are political matters. I'm not going there, but I just want to say when we are here now, what happens? And we put some of the things that have been happening. Badly bruised, a 21-year-old Venezuelan woman showed bruises all over her body on Friday at the immigration detention center in Arepo. In court documents filed the same day, the woman said she was raped and beaten by 3 Coast Guard officers at the heliport in Chaguanas last month. Then we have here, baby killed in Coast Guard drama. You might be able to read it. But a migrant Venezuelan boat was coming in with migrants in the dead of night. Coast Guard boat said the Venezuelan boat shot at them, they shot back. And a little thing, a little baby boy in his mother's arms was killed. And so I want to mention that I'm sure that is an area that you're dealing with in the TCI. And there was no way that I could deal with this properly in the time allotted today. But I think that this is something that requires an in-depth study and discussion facilitated really by experts in the field. I encourage you all to put that together at some stage, the JEI. The people from the Inter-American Commission, there's, I think, a rapporteur on migration and so on, and they know a lot. And so this issue of migrants and asylum seekers, it's not just for the Caribbean. Did anybody listen to the US presidential debate? It's a thing all over the world. You hear about it in the UK. You hear about boats of migrants coming into Italy, and everybody, you know, a little child drowned, and it comes in the news, and it's a big thing, and everybody runs to it, and then all of a sudden you hear nothing about it. But these people have rights. The Inter-American Principles, and I've highlighted that. I encourage you to get it. Inter-American Principles on the Human Rights of All Migrants, Refugees, Stateless Persons, and Victims of Human Trafficking, Resolution 419 was approved by the Inter-American Commission on Human Rights on the 7th of December. 2019. And I wanted just to go back to Trinidad and Tobago because of the issue here. Just prior to the COVID-19 outbreak, we had a lot of Venezuelans coming in by boat. Remember, we've always had interaction with them. They came here and bought stuff. We went there. People from deep south who are accustomed, that sort of thing. It was never a problem. But then they began to stay. Some came legally because they could have come in without a visa. And then some came illegally by boat. Some came legally and then they overstayed their time, so they were illegals. And the government of Trinidad and Tobago in 2019 instituted a visa requirement for them to come in. And then also in 2019, because so many were here, they were not what they want to work, they were working illegally. There was a lobby, you know, and so on. And then government decided that they would form a migrant registration framework so they could come and register and they could work. But of course, as you know, that is not the end of the matter because you have housing, you have terms and conditions where they work, where they're being treated properly, their access to health care and things like that. So if we go to the next slide, and this will be more or less the last of the slides. Crystal, you there? Yes. You have all these things. You have education for their children. Children were not in school until this September, when the Minister of Education, the government decided that they would allow them to come in. And for some reason that I certainly don't understand, up to August, only about 23 children had been registered, and there are a lot more than that. I know some were in other schools because some NGOs and faith-based organizations have been helping them. But you understand the role of sex trafficking and human trafficking when it comes to these things. So this was a raid that the police made at a guest house in inverted commas. I think it was last year or the year before. And these are the victims of the raid, but they have their hands up and their legs spread open as if they are the perpetrators of the crime. As I wanted us to just look at what these people go through. Among these people, there is on this wall somewhere a 16-year-old child. Okay? And so we need to, I don't have an easy answer, but we need to deal with it. We need somehow to understand that they've got human rights, and we are the protectors as the judiciary, as lawyers who come to the court. I know there's another side of the coin, because you can feel as if they're overwhelming your society. You can feel as if crime is going up and they're an easy blame. But at the same time, we've got to make a difference. So as I close, I want to express my heartfelt gratitude for your participation. I've appreciated it. I'll close and then I'll take any other questions. I wanted to say, I decided to do something I'd never done before. I asked Copilot AI, could you write a closing statement for me for training for judicial officers in the Caribbean? And they gave me this. Improving justice for vulnerable groups is not just a professional responsibility, but a moral imperative. By implementing the strategies and insights discussed, you have the power to make a profound difference in the lives of those who need it most. Remember, every step you take towards inclusivity and fairness strengthens the foundation of our justice system. Let's continue to strive for a judiciary that is not only just, but also compassionate and accessible to all. Thank you very much for your kind attention. Imagine AI told us all of that. And I want to thank again you for your participation, the JEI, Honorable Chief Justice and Honorable President of the Court of Appeal, and all of you in Turks and Caicos Islands, and to Crystal Charles, my judicial counsel at CCJ. Thank you, thank you, thank you. And I'm available to take any questions. Antonio, I think we have a few minutes. Any questions, any experiences, anything you wish to share, please do it now.
Yes, thank you so much, Judge. So we have just about 2 to 3 minutes for questions. So anyone who has a question, please feel free. Thank you very much.
Or if it may not be a question, but they want to share something that they think we would all benefit from, please.
Thank you.
Or perhaps I don't see anything. I don't see anything in the chat. So perhaps it is Antonio, what I would call in court, time for lunch. So
Yes,
thank you again, and I really wish you all well. We do such important work, all of us, whether we're attorneys, whether we're court staff, registrars, judges, magistrates, all judicial officers. We're involved in a wonderful opportunity to do justice for people who need it most. I used to tell my husband when I was an attorney that I only see people at their lowest. And if you know what I'm talking about, when you see them, I did a matter for a lady. I remember when we couldn't get to serve the husband with the divorce papers, he fled when we went to serve him, and my young instructing attorney kicked off her shoes and ran behind him through Port of Spain to make sure that the service officer got him. And I just think about, we saw that lady about 4 years after that event, and when the divorce had been finalized and she was back to herself. And I thought, thank you, Lord, it was all worthwhile. So I encourage you, don't ever give up. Keep doing the good work you're doing. We're all proud of you. Thank you, Antonio, again, for all your assistance. Yes.
Thank you very much, Justice Rajnauth. So I'd now like to ask Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give the formal vote of thanks. Ms. Carter.
Thank you, Antonio, and good morning to everyone. To Justice Rajnauth Lee, on behalf of the JEI of the TCI, we wish to thank you for your very insightful presentation on the various vulnerable groups. Your expertise and passion for this topic really shone through your presentation. Your presentation as well, no doubt, brought a greater appreciation to our judicial officers and to the attorneys present alike on the ways in which we kind of improve the manner of providing a more inclusive forum with respect to providing access to justice and equal treatment before the courts for persons who form part of these vulnerable groups. So we thank you for that. To Ms. Crystal Charles, thank you also for your support that you provided throughout this presentation. It was greatly appreciated. Once again, we say thank you to Justice Rajnauth Lee for shedding light on such an important but reserved topic.
Thank you so much, Ms. Carter. I appreciate it very much.
Yes, please. So that being said, I now hand this back over to Antonio to close off this morning's session.
Antonio, we're not hearing you. Sorry.
Thank you very much, Judge. I was saying that thank you very, very much. That brings this morning's presentation to an end. So we thank everyone again for joining us at JEI Week 2024. We hope that you will all join us this afternoon as we tackle social media and the judiciary. So please join us again at 1:30 p.m. And thank you very much. So this morning's session is over. Thank you. Goodbye, Judge.
Thank you very much. Bye.
Thank you.
Good luck. Yes.
Thank you.